Seeing Bryan Kohberger's notice of alibi reminded me of something from way back in the early days of this case.
He believes he's going to be exonerated. That's what he believes. Those were his words. So he's really been very easy to talk to, actually, and he's in a calm demeanor, like I stated.
The choice of this word, exonerated, has always stuck with me because that's a big hill to climb. But I think through this alibi notice, we are starting to see how he intends to get there. So we're going to talk about it. We're going to start by looking at the notice of alibi itself, both because obviously there's stuff substantively interesting in it, but also there are a few hidden gems in here that I think give us a lot of insight into where this investigation is at and what the defense is thinking about it. So the notice of alibi tells us that Mr. Kohberger moved to Pullman in June of 2022. He's an avid runner and hiker, so he explored many areas of the Palouse, including Wawaway Park in July of 2022, which became a favorite location. Once the school year began, he got busy with classes and work, and his running and hiking decreased, but instead of that, he did more nighttime drives. This is supported by data from his phone, showing him in the countryside late at night and or in the early morning on several occasions. The phone data includes numerous photographs taken on several different late evenings and early mornings, including in November depicting the night sky. This is significant, I think, for a couple of reasons. First, obviously, from the substantive standpoint, he's telling us he's not just making up a nighttime drive out of the blue for the first time ever, coincidentally on the night that these murders occurred. He's showing he has a habit of doing this, that it's not at all out of the ordinary for him to be out driving around late at night like he was on this occasion. So that's information that will likely be helpful to the jury in assessing the weight of this proffered alibi, but it doesn't specifically place him somewhere else at the time of the crimes. It's just showing he's got a pattern of doing this, so it's not consistent for him to be doing it on it's not inconsistent for him to be doing it on the night in question. But there's something else here that I think is quite important, which is this line. This is supported by data from Mr. Kohberger's phone, and also the phone data includes numerous photographs. This is telling us they have his phone data, okay? The police got his phone initially. They recovered it in the search from his parents' home in Pennsylvania. So we know now they've been able to extract it. They've been able to get data from it. They've been able to provide that to the defense, and that defense is now in their, information, that data is now in their possession. They've been able to provide it to their expert for his own independent review. So the data includes numerous photographs, but also just broadly supported by data from Mr. Kohberger's phone showing him in the countryside late at night. This definitely raises the specter of location data. Other location data, probably GPS, some other types of information like that can be available from a cell phone beyond this not very precise cell site location information that simply tells us which tower the phone pinged to. So this, I think, is very significant. Tells us that they have data from the phone itself that they are in a position to be able to analyze. Continuing on in the alibi notice, it tells us that Mr. Kohberger was out driving in the early morning hours of November 13, 2022, as he often did to hike and run and or see the moon and stars. He drove throughout the area south of Pullman, Washington, west of Moscow, Idaho, including Wawaway Park. This is more detail than we previously had about his location, his whereabouts on the night of the murders. We knew that he was claiming he was out driving around, but we didn't have anything specific. So this is a new development. We know now these are areas and directions that he claims he's going to be able to place himself in that would not be consistent with him being at the King Road residence. He says he can partially corroborate this with the testimony of Cy Ray. So first off, partial corroboration. He's saying that at least as of the time of this notice, he is not able to fully account for either all of his whereabouts or the entire time frame of the murders. So he is going to say, however, that Bryan Kohberger's mobile device was south of Pullman, Washington, and west of Moscow, Idaho on November 13, 2022. That Bryan Kohberger's mobile device did not travel east on the Moscow-Pullman highway in the early morning hours of November 13th, and thus could not be the vehicle captured on video along the Moscow-Pullman highway near Floyd's cannabis shop. There is quite a bit in this paragraph to break down. We know from the probable cause affidavit that when police began trying to retrace the steps of this white vehicle that they saw on camera outside the King Road residence at the time they think that the murders took place, they recovered a bunch of surveillance video from different parts of the community. And one of those was on the WSU campus showing a white car at the 2:42, 2:47 a.m. type of time frame going down Stadium Way to the direction of SR 270. The PC affidavit doesn't say anything about Floyd's cannabis shop, but the natural route to get to King Road, to get to Moscow altogether from this particular location, would be to make that turn onto SR 270, which then takes you east over into Moscow. So I guess we can infer from this that there is an additional piece of evidence that either police obtained after the fact or they simply didn't mention in the probable cause affidavit, which is a video on the highway near Floyd's cannabis shop. So Floyd's cannabis shop is, as it says, on SR 270. It's very close to the Idaho border, so quite east of Pullman and west of Moscow. This is significant because the probable cause affidavit itself has already kind of raised some questions about the consistency of Bryan Kohberger's movements with the consistency of the movements of the white car. In the PC affidavit, they claim that they were able to get the pings from his phone that showed him moving south from his apartment, and that was consistent with the movements of the vehicle that was seen on video. But we're getting some additional information here from this defense expert that he is going to be able to show the direction of the movement subsequent to those initial observations, that it did not go east, it went a different direction. And therefore, they are going to be able to separate it from the movement of a vehicle that the police have captured on camera and presumably are going to offer to prove that this was Bryan Kohberger's car traveling over to Moscow in the early morning hours before the murders took place. So there's a few reasons why they could have these different opinions. One could simply be the methods that they used. Mr. Ray, I'll talk about him a little bit more in a future video, but he has a technique that he has developed where he is able to kind of do some mapping, some cell phone mapping based on the transmissions from different cell phone towers. So it could be that his technique produces a different result than the technique that the feds used. But it could potentially also be something a little bit more nefarious. It could be that the feds either disregarded evidence when they were doing this reconstruction or, potentially didn't disclose certain parts of it. Why do I say this? I say this because there have been hints throughout this entire case that there is a problem with the FBI analysis and that Brady is implicated. Brady versus Maryland is the U.S. Supreme Court case that establishes that as a matter of due process, Prosecutors and their agents, meaning including law enforcement, they have a duty to turn over any and all exculpatory evidence that comes into their possession during the course of an investigation. And exculpatory evidence includes impeachment. It includes stuff that maybe you don't believe it, but if the defense had it in their possession, it would tend to undermine the testimony of one of the state witnesses. So it could be, for example, when an expert relies on certain data to produce an opinion, if there is contradictory data that would tend to undermine it, that data is going to be subject to the Brady requirements. I bring this up because it was as early as, I think, the second motion to compel that was filed in this case that dealt with the FBI's CAST report. This is the report that does the reconstruction of the locations based on the cell site location data analysis. And the defense invoked Brady for the very first time in this context, where they said, we believe that the report and the information it relies on, essentially they're saying it could be potentially exculpatory. It needs to be produced. We never saw any type of motion for sanctions or anything like that. So the implication here is that the report itself did get disclosed. It was ordered to be disclosed at the hearing on that motion. Deadline was presented. And so it appears that probably did happen. Now, what's kind of the normal course of events with an investigation like this from the defense standpoint is you get the expert's report from the state. They may or may not provide all of the data that they relied on in the initial discovery. So oftentimes you have to go back and do follow-up requests for additional discovery. In my state, this is really common with like DNA testing, for example. They will produce a report that shows you this is the test that they did, the dates that they did it, how they handled it, the conclusion that they reached, the statistical likelihood calculation. And that's essentially what you get in the initial disclosure. So if you want more, like I want the actual data, the electropherograms is what they produce to basically analyze the genetic code. If you want more of that data, you have to specifically go in and ask for it. And then they'll typically produce it to you in a digital format. But it isn't something that is just routinely handed over because often, you know, it's not necessary. There's like so much other corroborating evidence or the defendant admits it and is going to plead guilty, so you don't have to do a big DNA investigation. Those are the types of things that can, you know, make that not really be necessary in the case. So I would suspect that something like that is at play here, that they did get the initial FBI CAST report. They're able to provide that to Mr. Ray, who is their expert. And Mr. Ray is then able to look at that report, and he's able to identify a lot of information from that. He's going to be able to tell, first off, did they get all of the information that's available? He's going to know what's available. He's going to be able to see, hopefully, what they relied on. And so he'll be able to see if there's gaps in that. Did they rely on something or did they fail to rely? Did they fail to take into consideration something that would ordinarily be available for this type of analysis? He's also potentially going to be able to evaluate the conclusions that they reached from that data. So if they did, in fact, produce the raw data at this point in time, the expert's probably going to be able to look at that and peer review it, in essence. Decide, does he reach the same conclusion as this expert does? And if he does not, why not? What is the difference between the basis for his opinion and the difference for the basis for the state's expert's opinion? So these things come about a lot when you're dealing with experts in criminal cases and how you kind of go through that process of forensic investigation. But the real key takeaway here is really that from the outset, with this particular piece of evidence, this FBI analysis of the cell phone data, the defense has suspected Brady issues, that there is something exculpatory here. And I'm going to continue on with why I think that is particularly significant. The final paragraph of this notice of alibi is where a lot of the meat is in this Brady issue, because Ann Taylor states additional information as to Mr. Kohberger's whereabouts as the early morning hours progressed, including additional analysis by Mr. Ray, will be provided once the state provides discovery requested and now subject to an upcoming motion to compel. If not disclosed, Mr. Ray's testimony will also reveal that critical exculpatory evidence further corroborating Mr. Kohberger's alibi was either not preserved or has been withheld. They're saying the state has evidence relevant to Mr. Kohberger's location during the early morning hours that they have not produced, and that if they don't do that, their expert is going to say that the explanation for that is one of these two things. They destroyed it, or they are simply not turning it over. This is a big deal. This gives us the hint to what he has seen based on his review of their state's case. And the implication here is that there is additional information, additional data that should be available that for whatever reason, it's not. It has not been handed over. The defense has had to request it, and so far it has not been produced. We don't know exactly what the details of that are, but the suggestion that it goes to his whereabouts as the early morning hours progressed suggests that there is additional data available beyond these cell phone pings that stop at 2:47 a.m. when his phone goes out of service. Could be a couple of things. Could be the possibility maybe his phone didn't go out of service. Maybe it came back on earlier. Maybe there's other cell phone data there that the state or the FBI did not acknowledge. But the other possibility remains there's GPS data. And there is a reason why I think this is a decent probability in this case that I'm going to talk about now. So we have confirmation from this notice of alibi that police were able to extract data from Bryan Kohberger's cell phone. But there's more than just that. There have been search warrants to Google as well. As early as back in the very first days of this case after Mr. Kohberger was arrested, police originally got a warrant for his Google account information, including location data. They got this back in February of 2023 based on his Gmail account. Subsequently, they filed an additional search warrant that essentially requested additional possible account information for Bryan Kohberger. Basically the same type of data being requested, but just in case he had accounts under other Gmail identifiers that could then be associated with his devices. So these are ways for law enforcement to be able to track what they see. If you get a cell phone, for example, people often have control over the data on your phone. And the very simple example of that is you can delete photos that you take and then you won't be able to access them in the Photos app on your phone. But that is different from the information that is stored in the server that Google maintains. And so one of the ways to look and see if somebody has been modifying their cell phone data is you compare what you're able to obtain from the local device with the information that is stored on the server. And then that way, if there is discrepancies between those two things, information appears on the server that's not available from the telephone. A potential explanation for that is user deletion. They went back in and deleted that off their phone. So this is common. Again, as an investigative technique, you download the phone, but you also go to the source. You get the Google account information directly. So we know that they have had all of that information since at least March of 2023. Now, It seems to me that this is going to be one of the most critical pieces of the case. If there is GPS data on this phone and there is guaranteed to be at least some GPS data associated with this telephone, then that is really got the potential to be dispositive in the case. GPS is precise to a degree that cell site location data is not. Even cell site location data that is based on triangulation between multiple towers is more precise than cell phone signals based on just a single ping. I talked about this in a very early video I did on this case about the pings and the ping information in this case. The way that it's described in the probable cause affidavit is not clear. They just use the expression utilizing cellular resources. So if they have a triangulation, that's likely to be better. But GPS is going to be better than any of that. So that is very much a potential area of interest here for the defense to be hammering in on. If there is GPS data that puts him somewhere else at the time of the crime, that is going to be a game changer. And why would GPS be available when cell site location data is not? It's because they use different transmission systems. The cell system is based on land-based towers. And so those towers, you know, they're set at different heights or whatever, but you could run into problems with service, particularly in areas like these that get a little bit hilly, because the land will block the transmission. You don't have that problem with GPS because it's a satellite-based system. So there's no mountain high enough to be able to block the transmission between your cell phone and a satellite up in the air, unless maybe you're like literally underground. So GPS can pick up a lot of information that the cell towers will not be able to get. This is critical. This may be what the defense is talking about when they say that Mr. Ray is going to offer additional information about his location, because they have held that door open with him being the radio frequency guy. GPS is another form of a radio frequency location. It's, again, different system, and there's going to be a lot of different math involved and stuff like that, but it's the same general principle. So if that data is available and the state has not turned it over, that would be, in my opinion, extremely telling. So based on this, I think we're likely to get a much better idea of the direction all this is going from the motion to compel hearing that's scheduled to take place on May 14th. The motion to compel itself is still rather shrouded in secrecy. We have the motion, and we know that it's dealing with 14 separate items that have been requested at different points in time, but we don't know exactly what those items are because that information has been filed under seal. If we hear what those items are in the motion hearing, then I think that's going to shed a lot of light on this part of the process, that the defense has indicated this motion to compel is relevant to Mr. Ray's analysis and the location data analysis. So here's where we could be looking at cell phone data, additional cell tower information, and of course, potentially GPS data as well. So to bring us back full circle to where I started this video, I think there is very possibly a reason why Mr. Kohberger used this word exonerated, and why he was so confident and calm that his defense would play out in his favor. And the reason why is because, remember, this right here, this is Bryan Kohberger's specialty. This is what he was studying as a criminologist. The probable cause affidavit tells us he's got a degree in cloud-based forensics. He is going to know precisely what type of information is available through these types of cell and server networks. So if Mr. Kohberger, in fact, was not the perpetrator of this crime and knew that he had his phone with him somewhere else than King Road on the night of the murders, that he would know. Eventually, all of this information is going to come out and it's going to exonerate him. So that's really a development that I think would be unexpected for quite a few people who have been following this case. But I just got to close by noting who it would not be surprising to at all, based on all of the information that they have at this point in time, is Bryan Kohberger's defense team.
Our defense team firmly, and I mean firmly, believes in Mr. Kohberger's innocence.